Okay, ladies and gentlemen, gentlemen and ladies and gents, we got Taylor Dane in our background. And I'm not gonna pull back, not gonna pull no punches. If you do something and you ain't had no business doing it, I'm gonna let you know you ain't had no business doing that. What's wrong with you? You gonna hear that from me, y'all. Why? So that you don't end up doing the same stupid stuff again. I'm gonna be not real with you. I'm gonna tell you the truth. Because I don't have no other choice, ladies and gentlemen. If I lie to you, you get in trouble. Why would I want you to get in trouble? That's not what this is about. Look, many of you who do arbitrations, who've been trying to do arbitrations, you haven't been knowing what's going on. We can go here. Now, this is just the federal rules of court, okay? And that's the rules for that Circuit Court of Appeals. The Federal Circuit Court of Appeals, that's their rules, okay? Now, I'm not really concerned about that court, so we're going to go back twice. Let's see. Google. No, I don't want that. I just told you I didn't want that. Lord have mercy. Give me what I'm asking for, Google. Google don't like me, y'all. I don't really want to be in Google. I don't want to be searching nothing Google got to offer. I'm sorry. I'll search Google, but I'll search the other algorithm for Google. Let me see. Did I put it in Opera? Or did I put it here? Advantages and disadvantages. Hold on. Ladies and gentlemen, this is Luther. No, that's not the one. This got to be this one then. It's got to be Opera. Let's see if this is Opera. Nope. I don't know which one I had it in, ladies and gentlemen. I apologize. Let me go ahead and tell you guys about this right here. Well, as a matter of fact, we can go in Opera. I can show it to you. Because many of you guys don't know what's required when you're walking into these courts. So you're getting slapped across the side of the head. Hold on, ladies and gentlemen. We're going to put in 9 USC 13. Ladies and gentlemen, this is Wait for Love. I remember not so long ago. I was just a lonely person with a lonely heart. Yeah! Luther Vandross, everybody. The late, great Luther. While we're waiting for this to pull up, ladies and gentlemen, I don't think many of you understand about me and Luther. When he came up with his first album, man, fan of Luther. But he came up with some other albums, and I wasn't really a big fan, so I didn't listen to him. I listened to that first album and just pretty much not nothing afterwards. And it took a couple of years, but then Luther came up with Dance with My Father. And this was after he had his stroke and everything, and I'm like, man, that song is all right. And I listened to Dance with My Father, and I became a Luther fan. Then I went back and listened to all of his other stuff that I had heard on the radio, but never really downloaded. Man, I downloaded everything that man ever did. All right, let's talk about this, ladies and gentlemen. This is Federal Arbitration Act, Section 13. The party moving for an order confirming, modifying, and or correcting an award shall means you must. At the time such order is filed, you must file an order, ladies and gentlemen. You must file a proposed order. Not the order of the court, but your order. Interesting how they wrote that, huh? With the clerk for entry of judgment, you're asking for a judgment of the court. Also file the following papers with the clerk. Now, because it's a judgment of the court, the motion to confirm, the reason why they say that it's a judgment of the court in the court cases is from here. Okay? Order confirming an arbitration award becomes a court judgment. You must file the agreement, ladies and gentlemen. You must file the agreement, and if they ask for an extension of time, you must file a copy of any request for an extension of time. If there's a request to add an additional arbitrator, you got to put that in there as well. Okay? You must file a copy of the arbitration award, obviously. Many of you are only filing the arbitration award. You cannot do that. You have to file all of these documents with it. Each notice, each affidavit, or other paper used upon an application to confirm, modify, or correct an award, and a copy of the order from the court of such application. Let's say you applied for confirmation of your award, and the court said, man, we ain't hearing this junk. Get this book out of my face. You got to attach a copy of that. Okay, you have to. You lose if you don't. The judgment so entered shall have the same force and effect in all respects as and be subject to all provisions of law relating to a judgment and an action. And it may be enforced as if it had been rendered in an action in a court in which it was entered. You feel me? This is what y'all need to know. This is what many people are making a mistake. So, ladies and gentlemen, what we're going to do, this is going to be, well, we can't put it on SAA. Sorry. This is going to be on SATCOM. SATCOM! Okay? SATCOM! Okay, this is going to be on SATCOM. Ladies and gentlemen, it's going to be on SATCOM. We're going to put it in, I don't know which folder we're going to put it in. We'll figure it out in a minute. Now, you see it says a petition for summary order, cover sheet, and motion to confirm arbitration award, supported by affidavit. Ladies and gentlemen, of course you're going to call this an affidavit. You don't need to get it notarized, but if you want to get it notarized, you go write yourself on the head, but you don't need to. I'm waiting for it to catch up to me, ladies and gentlemen. They get a chance to love, wait for love, and yeah. Luther Vandross, ladies and gentlemen. Sometimes love, it takes a long time. Wait for love, you're gonna get your chance to love. Ladies and gentlemen, this is Tina Marie, and she's singing the song, If She Were Your Belle. Then she wouldn't be Tina Marie, she'd be your belle. So I'd prefer her if she just was Tina Marie. The late, great Tina Marie, ladies and gentlemen. You notice how many of the artists I listen to are late greats? Well, ladies and gentlemen, there's a reason these artists are late great that I listen to. Because many of them, because of old age, but quite a few of them, ladies and gentlemen, because the system decided that they could make more money off of them dead than if they were alive. If you don't believe me, go look at Mr. Rogers Nelson. There was no reason for Rogers Nelson to be dead at this time, ladies and gentlemen. There was no reason. I'm trying to figure out what folder I'm going to put this in, so y'all give me a second. No. All right, ladies and gentlemen, when you go to our website, let me see what's in here. No, we can't put it in there. I don't want to put it in there. That's too much. I don't want people to get confused. I'm so confused. You know what? We're going to put it in number 1. See, there are 2 number 1 folders. Okay, but we're going to put it in the first number 1. Okay, this is the preemptory challenge, article immunity, motion for reconsideration and vacating of whatever. We're going to put it in that motion. Ladies and gentlemen, reconsideration, vacating of judgment in the interim, a motion to dismiss. Okay? We're putting this in this folder because you all deserve it. All right? So I just want to let y'all know. Let me see if I have to go. Come on, get on out of here. Right there. No, we're going to go to access. All access. And I know that this speaker... Oh no, I wasn't supposed to do that. I keep doing that, ladies and gentlemen. I keep opening up documents. It's already open. That's what I'm talking about, y'all. I keep opening up documents. Close. I've been doing that all day. You know what? I don't know why my... Uh-oh, that was me, y'all. I did that. I apologize. I apologize. I hit something on my phone for iHeartRadio. Ooh-wee. This is Believe, and we're gonna let it play. Got rid of my Tina Marie. I am so sorry. Would you? Oh, if you believe, ladies and gentlemen, that share person. You believe in love. If you believe in love. If you believe in love. If you believe. We're gonna process that, ladies and gentlemen. This document. This is the sample template of a motion to confirm. Now let's show you what the motion to confirm includes for your benefit. Identity of the parties, again, your name. You're gonna have to put the city and state. Hold on. I'll re-upload it in a second, ladies and gentlemen, because we need to... You see where it has all California, we're gonna replace. And let's go here and pull words only. And I need the format. So give me a second, y'all. I need to format it, and I need to change the color. Go highlight. No, I don't want to highlight it. No. Let's unhighlight. Can't highlight. Okay, we need color. Y'all just have to excuse me. I just need to make sure I choose the right one, because it's been a while. Let's see, special. Nah, I need color, not highlight, because highlight will be that yellow thing, and I don't want that yellow thing. I can do it this way. We can make it bold italics, and we'll make it there. No, let's make it... Yeah, we can't do it the way I want to do it, so we're going to make it 13. No, we'll leave it at 12, because many of you guys won't know how to undo what we're talking about. Replace, you see? We'll put it italics, okay? That works for me. Replace all. Okay. So that's the first thing. Now we need to take care of Los Angeles. Copy. One second. And ladies and gentlemen, oh, only one Los Angeles. Thank you. Lord have mercy. Let me see. I just wish. Let's see if I can do this, ladies and gentlemen. Let's see if it'll let me replace one. Oh, it won't let me replace it because the one that I'm doing is already bold. So let's see if we can do this. You know what? This song, there is a moment that it brings back, a recent moment. And that recent moment is... John Legend and the Roots, ladies and gentlemen. They sing in Hard Times. Reminds me of a song done by the young man. Why can't I think of his name right now? The one who sings... Dang it, why can't I think of I'm the Man? Why can't I think of that young man's name right now? As much as I played him all summer long, see, in my mind it's saying Citizen Cope, and I know he ain't Citizen Cope. Hold on, y'all. I gotta pause. Nope, I cannot think of his name. Aloe Black. That's who it is. This song right here sounds like something Aloe Black would make. All right, ladies and gentlemen, let me explain to you how you define diversity of citizenship. If it's a federal corporation, pay attention. If they are a federal corporation, then that's your diversity of citizenship. You have state citizenship, federal citizenship. That's the 11th Amendment. Okay, that's your diversity of citizenship. If it's a bank, they're part of the Federal Reserve. They're members of the Federal Reserve. They're one and the same. That's federal government. You're a state citizen. That's diversity of citizenship. Value the property more than $75,000. You've satisfied the prerequisites of diversity of citizenship and jurisdiction. That's what you have to put in your document. So, guess what? We identify the parties. We put jurisdiction and venue. Pay attention. Diversity of citizenship, jurisdiction met. However, the contractual agreement between the parties permit the petitioner to seek confirmation in any United States District Court. I'm not going to put the code there. That's where you get the authority. It's from the Arbitration Act. The Arbitration Act says that you get to make the choice. All right, and then there's your verification and validation under penalty of divine retribution. Depends on who you think your divine is. All right, this is your memorandum of law, affidavit. Now, you are going to have to go back through this, ladies and gentlemen, and let's get rid of this. We're going to do this as in Alibaster. Alabaster! Man, what happened to that alabaster mother? Okay. All right. And with that being the case, this is what I've added to this as of now. As indicated above, a valid agreement, in other words, a valid agreement is an agreement that contains elements such as, it won't let me do nothing, so y'all give me a second. Oh, by the way, you see this? If the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration and shall specify the court, then at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award, and thereupon the court must grant. This is what gives the courts jurisdiction. Okay? The courts don't get jurisdiction because of diversity. The courts don't get jurisdiction because of the dollar amount. The courts get jurisdiction because the law their law, Federal Arbitration Act, grants them jurisdiction. Okay? Sorry, my computer's running a little slow. Somebody help that man out. He's having some hard times. He's with the roots. And when you're with the roots, you shouldn't be having any type of hard time, ladies and gentlemen. All right, a duty to respond, meaning a prior relationship, accompanied by a notice and change in terms of a prior agreement. An opt-out clause, an expiration date, an Arbitration Act clause. A duty to respond, is doable, workable, is between consenting adults, and has a commerce clause. That's the validity of a valid contract. Ladies and gentlemen, you put the dollar amount in. Then explanation. This basically explains pretty much for the most part. Go over it, amend it to fit your situation, okay? And there you go. Now, there's one other thing we added, okay? Not the conclusion, not the vivification. Who will be this? This is... No. Give me a second, y'all. The person that they had up there, I didn't choose that individual. Okay? And I don't trust songs where I don't know, because I don't want nobody cussing in my background. Bothers me. Bothers me greatly. Okay. Ladies and gentlemen, every place in red, as always, you gotta change. Sorry, I got a homeboy that's flying in here. I missed him twice, but that was getting warmed up because I haven't used this all day. But he and I gonna talk. My love. Now, these are all the items that are supposed to be attached to your paperwork. Okay? Motion to confirm arbitration award, memorandum of law, cover sheet. You have to do a federal civil cover sheet, ladies and gentlemen. You file it under miscellaneous. File it under miscellaneous. This is a miscellaneous filing. Certified copy of arbitration award. The contract. Proposed order, which is attached to this. And any order or mandate from any other court, if you have it. Okay? Read. I have attached the private law, otherwise known as the Bradley Christopher Stark Act, to my presentment of memorandum of law in full reliance on the principles, facts, findings, conclusion of the United States Congress, and with reference to the agreement of the like format of private federal arbitrators being recognized as capable of rendering honest, fair, and impartial decisions respecting parties and their agreements. And I present this body the fact that the aforementioned agreement was processed in the exact same manner as Mr. Stark and his beneficiaries, and as Congress indicated, it is such as binding, valid, irrevocable, and enforceable process that must be honored. So much so that they overrode the presidential veto, bringing that point home. And this is the Bradley Christopher Stark Act, embedded in your document. Many of you have not been including it. If you're going to go on appeal, you want to rely on this legislation. Then the next section, remember, every section that has the title of district court should be the very beginning of its own page. Especially if you're typing things in, these pages will shift. My love. Proposed order for a summary disposition confirming arbitration award and judgment. Ladies and gentlemen, you're asking for a summary judgment. That's why it says and judgment. You're asking for a summary judgment. You're going to put your name, information, but I want you to know you're going to have to edit some of this. Now, we list all of those 10 things, that there was a prior agreement, that there was a conditional acceptance of an attempt to change the terms of agreement by the claimant. Okay? The petition. And the conditional acceptance had an opt-out clause. We're going to put the hyphen in the opt-out. I got about 4 opt-outs that I got to put a hyphen. Okay, but it had an opt-out clause, ladies and gentlemen, arbitration clause, and a commerce clause, which the law requires. Within the specified and specified and agreed time as prescribed in law, and the agreement is considered and deemed binding upon the parties. Oh, would you stop? As determined by the arbitrator. The agreement is doable, workable between consenting adults. The agreement has an expiration date. As noted, an opt-out clause. God, that's the fourth one. I told y'all about four. God bless me. As noted, the arbitration clause is noted the commerce clause. And as the petitioner has applied to court with proof of service, you got to put your proof of service in here as well, upon the opposing parties who had a duty to respond in good faith as a result of the prior agreement between the agreement between the parties. And this court finds, this is a proposed order, that the opposing party enter their name. You don't enter their name, that's for the court to do. You can enter their name, but technically that's left for the court, but you can enter their name. Okay, after receiving notification, as approved by the record. No, it's not as approved. Sorry. As proved by the record. Ladies and gentlemen, can somebody help me? Because this is Tears for Fears, and they're talking about shouting. You didn't have... I'm sorry. Ladies and gentlemen, did knowingly, intentionally, deliberately fail to respond, which according to the terms of the agreement is construed as conduct and or performance amounting to assent to the agreement between the parties, and that the petition should be granted. It is ordered that the award of name of the arbitrator is confirmed in all respects, and that judgment entered in conformity therewith. Ladies and gentlemen, I want you to know that most of this language is coming from an actual document by the courts that they put together. Okay, we just took their proposed order and gave them what they've been looking for. Ladies and gentlemen, many of you are having your awards kicked out because you're not understanding what's going on. Ladies and gentlemen, let me help you understand what's going on. When you're taking your arbitration award into the court to have it ruled upon, to have it decided upon, you need to do it the right way. Not the way you think you want to do it. You need to do it the right way. Follow the rules. Because when you go before the appellate court, you're only going to highlight the fact. That's it. You're only going to reiterate the facts that are already here. You don't need to explain anything else. You don't need to convince nobody. Follow the law, people. Raquel will say peace. Okay, the award, name of the arbitrators, having been confirmed by order of this court on this date, this court having made and caused its statement of decision to be filed in this case, no statement of decision having been requested by any party, this court further finds that the opposing party, enter the party's name, had an opportunity not only to participate in the arbitration proceeding, but opted out of the agreement initially, and after notification and expiration of time are barred for the estoppel clause of the agreement between the parties. That's right, estoppel. They can't do anything once they receive the award. Okay, hold on one second. My dogs are digging a hole. And you know what? I'm going to let them. Because when I say they're digging a hole, it's about about 1.5 feet deep already. And see, because they have a cage, I don't want them digging underneath it. You follow me? Now, I think I have a solution for that, and I think that my solution will work out, but my solution entails a lot of work on my part, and I don't feel like doing all that work. All right, let's continue. By failing to participate in the arbitration hearing, they have waived their right to contest the findings of the arbitrator. This court notes that the opposing party, this is the part you're going to have to amend, that the opposing party in this instance did request in a letter to the arbitrator for an extension of time. The private independent arbitrator was not under obligation to give an extension of time under Section 10 of the United States Federal Arbitration Act, as the notification by the arbitrator explicitly gave the respondents 10 days after receipt of notification to provide any responses and or objections, and thus the request for an extension of time is invalid as time barred. The court also notes that the communication between the opposing party and the arbitrator, I need to change arbitrator to all caps, ladies and gentlemen. Give me a second. Well, not all caps, but capital lowercase caps. Some people are made of wood. Some people. Ladies and gentlemen, this is the dramatics. They want you to know that sometimes what you see is what you get. Some people are up to no good. But maybe I'm for real. How many of you guys heard that? I'm for real? Because I'm as real can get. And what you're looking for is real love. Then what you see is what you get. Wow! Ladies and gentlemen, I'm waiting for my computer to catch up. So I don't mind listening to the dramatics. Man, they're so dramatic. It's what you get. Come on, computer. What you see. Let me pause, y'all, because that's the problem. 1 second. Okay, ladies and gentlemen, I had to make some corrections with arbitrator and put it the way it's supposed to be. So every time it's an arbitrator, it's now a United States federal arbitrator, because most of the agreements that are put out there for people, let me make sure I have to change arbitration, or under the United States Arbitration Act. And so I'm gonna capitalize all arbitrations. Best thing yet. And I gotta be careful because this is the, I need to go backwards. And now I do replace. Now I do find next. And now I capitalize. He always capitalizing. No, ladies and gentlemen, I don't know. You know what? I know what's going on. Okay, I see what's going on. It's not my playlist. They're doing a radio thing. And I'm going to have to go past the stylistics, ladies and gentlemen, because I did not select those songs. It's doing that on its own. And I didn't give it permission to do that. Okay? I surely didn't give it permission to do that, because I have the ad-free version of iHeartRadio because it's a mod. And because it's a mod, they don't like the fact that I have an ad-free version. So replace that. See how I'm doing? All the arbitrations, we gonna capitalize because it's a proper noun. Well, you know, it's not like a proper noun. It's a proper pronoun. And because it's all pro, it's full nouns. Okay. My love. This is Tevin Campbell, and he's saying his love ain't blind, y'all. All right. So, as I said, ladies and gentlemen, in this document, we're going to go down to the order again. This document used to be 11 pages long. It is now over 23 pages long. No, I think it was 8 pages. So I apologize. Let me correct myself. I apologize. Back to the court thing, ladies and gentlemen, where we were doing the court. Again, the section we said you're not going to keep in, you're going to have to take out the section of this that don't fit. This court also notes that the communication between the opposing party and the United States federal arbitrator amounts to engagement and or participation and or conduct and or performance, and they were thereby bound to the principles and procedures of the United States Federal Arbitration Act in that regard. We're going to do act as well. We're going to capitalize act. Ladies and gentlemen, let me explain something to you because I don't think that you guys understand what's going on here. If the other party responds to the arbitrator, that act, that response is an act. That act is considered performance or conduct. As long as it's performance or conduct, it can amount to assent, consent, performance, or conduct. Okay, we replaced it in the whole document, y'all. It's only 6 times it says. All right. Anyway, the point that we need to bring out to y'all attention is right here. Conduct, performance, participation. That although this award was issued November 19th, we're going to do this right here for y'all. We're not going to highlight, well, we're going to highlight everything. You need to check all the highlighted words to make sure you don't need to change anything. With consideration for delivery time and service of the award upon the opposing party within 1 year statute of limitations for confirmation of an award was told as a result of the filing of confirmation before the Court of Appeals for the Federal Circuit. As per the statute of limitations general rule, the tolling of time does not commence to run until the last overt act has been accomplished. As such, this is supposed to be capitalized. I forgot to change it earlier. Don't sleep on that, boy. This court finds that due process has been afforded the respondents in this matter and thus concludes, as the United States Congress did in Bradley Christopher Stark matter, that the award is binding, that the agreement is valid, binding, and enforceable and irrevocable as prescribed in law. It is adjudged that the petitioner, your name, you can add your name here, recover from the respondents, the name of the respondents, this amount, together with interest. You don't add an amount there, per annum, from whatever that date is. Let's go ahead and make it to where they know we mean the date. Okay, we'll do that. Then we'll do that. Ladies and gentlemen, this is the Eagles. One of those nights. It's just, didn't it always feel like one of those nights? Just one of those nights. Y'all know what nights I'm talking about. One of those nights. That's it. Didn't it always feel like that? Ladies and gentlemen, this is the end of the document. Okay, there are a couple of spots that I do need to change to red just for you guys. I'm not going to be able to change everything because guess what, ladies and gentlemen? You're going to put the case number here at the top. Okay? You're going to double click. See, wait, hold on. Double click up here to get to this area. You're going to add your name and leave petition to confirm alone. Okay? That's what, I'm just making suggestions, y'all. See this right here, Long Beach? So, what we do is this right here. Bold that. We're going to put bold. And we definitely going to color this one. And we're going to colorful this one too. And let's see, what else I need to, we know that can be okay. The $75,000 to be okay. All right, now we come here. I know there are a couple of instances that I have to highlight and put stuff in red. And so I want to take care of most of it because I know a lot of you don't take the time to read. For whatever dumb reason that is. I understand that you think you can just phone it in. All the people I've been talking to have been calling me, asking me, what do we do next? How do we handle this? How do we handle that? Ladies and gentlemen, I'm showing you every single video how to do the research yourself, how to find the information. Why do you think I go through all of this? This is showing you what you need to do. I got to move this up. Now, I ain't finished, y'all. You know why I ain't finished? Because I got to make sure that the pages line up. Okay, see that certificate right there? Let's make sure there ain't nothing else that I'm supposed to be doing. And you had better believe nothing is under the penalty of nobody's stupid perjury. It's under the penalty of divine retribution. Let's do that right there. Ladies and gentlemen, you always sign before your name. You always sign underneath your printed name. If you're going to print your name, you always sign under your printed name. Hold on, y'all. Just trying to make sure there ain't nothing I'm supposed to be highlighting here. See, like this right here. If you don't know the attorney's name, don't worry about it because that's for the judge to fill out. Okay? You're just going to complete as much as you possibly can. Okay? Because we don't want a crackhead coming at you saying that y'all know what you're doing. What's the you think you're doing? We don't want nobody coming at y'all saying something stupid like that. Okay, there we go. See, that's what I'm trying to do, y'all. That's what I'm talking about. That's me yawning. I have been a little bit extremely tired lately. Been falling asleep at 6 o'clock every evening, ladies and gentlemen. Literally. If it hasn't been 6, I've been in the bed at 6 and going to sleep before 8. The last 2 nights has been about 6:30. And like I said, I'm still on daylight savings time, so I am having daylight saving lag. Okay, let's get rid of that. And now, ladies and gentlemen, we have to do one final thing for y'all. We're going to do fail check. Hootie and the Blowfish. This is called Answering Machine Man. Nah, just kidding. Just answer man. Man, would you just answer? Mother. Okay. I don't know. Like I said, I never listened to Hootie and the Blowfish when I was younger. Knew they were out there, knew who they was. You better believe I'm going to change that. Okay, I'm going to change that too. Is that another foe? Where you at, foe? No, we're going to keep you for the amount. We're going to ignore that. Nope, we're going to ignore that one too. We're going to correct that space because that space is too much. That means it's going to happen event. Hold on. Oh no, we're going to keep aforementioned. You ain't getting rid of aforementioned. You ain't getting rid of aforementioned. Irrevocable. Irrevocable. I don't know why I don't like aforementioned. You definitely gonna ignore that one. Ignore, 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 ignore. No, 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 no. Say, ladies and gentlemen, I apologize, but this is just what we have to go through. Because this is the Bradley Christopher Stark Act. We ain't changing none of that because that's the act itself. You see, here's the thing. No, I can't go up too far. because what will happen, it'll send me through all of that all over again. So what I have to do is I have to go to the top of this document and then continue. God, would you get out of here? I didn't ask for you. Come on now. All right, we're going to start here. Resume. Resume. Somebody resume. Oh, resume. Resume. We're going to change that. Would you hurry up? That is me yawning again. Oh, ladies and gentlemen, I'll be laying some towel in just a second on the floor. This is Bobby Brown, and he's singing a song about tender romance. It's from that album he did. Y'all remember that? I believe it's the My Prerogative album. Okay, nope, it's the Bobby Brown album. Bobby Brown. Okay, Rick James. Bobby Brown. Let's hit for sex chocolate. Sorry, apologize, y'all. It ain't letting me do nothing, y'all. It's like you need to put them back on hold again. So give me a second. Okay, ladies and gentlemen, I finished the spell check, and now we're going to upload. So we're going to process that Q. Yo, what up, Q? Young man named Jeremy Sullivan changed his name to Qui-Gon Jinn Q, and haven't heard from him in a while. He was a very alright young man. He even battled Mr. Eminem and beat him, and Eminem became Eminem. But Mr. Sullivan, Jeremy Sullivan, Qui-Gon Jinn, very, 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 very unique person. Sorry, was just thinking about that when I was doing all of what I was just doing. You know, upload to the queue. All right, ladies and gentlemen, the document is done. It's uploaded. It's updated. It's saved. It's there for you guys. Confirmation of your arbitration award. Okay, ladies and gentlemen, if you've already gone in and had your arbitration award summarily dismissed, go back in and do a motion for reconsideration and put back in your motion to confirm. Okay, just that simple. Let's see if I can get this whole sentence in this. Ladies and gentlemen, this is Lisa Fisher, and she's going to take us out of here. If y'all don't know about Lisa, Lisa's got a lot to say. I think that this woman can sing. All right, for those of you who don't know what this document does or what it is, then don't worry about it. But there's going to be quite a few of you who understand exactly what we're doing here. Okay, bring up the information that's in here. This is what will save you. I didn't highlight this, and I'm sorry about it, but y'all gonna take care of it. Okay? I gotta go. Me and Taylor, we got a date with the flow, and I got some documents I gotta finish. Y'all take care. Have a good day. Have a good night. Have a good time. But how can I ease the pain?